Thank you very much. And for this closing section, we will have the chance to hear from Judge Guillou a summary or conclusions of everything what was being said. Judge Guillou accepted this challenge. Let me say that it's not easy at all, but he was working a lot during these 2 days. And so the floor is yours.
Thank you very much, Madam President. Please allow me to start with thanking you for this wonderful conference. And if you allow me, I would also like to thank your team, who has done a fabulous job. You've treated us like VIPs throughout these 2 days. Everything has been wonderfully prepared. So big round of applause for all of you, because without this effort before and during this conference, it wouldn't have been possible to have so many interesting ideas. And you actually made my work easier, because you said so many interesting things that I just had to listen and type on my computer for the past 2 days. So around the world today, there are 2 words that we hear a lot: fragmentation and polarization. Fragmentation because some states move away from cooperation and choose competition or confrontation. And for our multilateral institutions, we are the collateral damage. Polarization because the algorithms put all of us in a sort of virtual bubbles, and they tend to radicalize our views to maximize profits for a gigantic tech and social media platforms. And we've heard yesterday that hate speech online is one of the results of this extreme polarization. But I'm optimistic. Our 2-day symposium has shown that our institutions are a hope, but they are also working and that they can produce results. They need to be further strengthened. And for our institutions to be the antidote against fragmentation and polarization, our debates showed that we need 3 things. We need an inclusive architecture to build efficient institutions through a truly hybridized system. First, we need an inclusive architecture. To prevent and punish atrocity crimes, our discussions showed that we need what I would call judicial hubs. The Hague in Europe has been a hub for a long time, but we need hubs in every continent. Arusha is and should continue to be a strong judicial hub in the African continent. Why? Because it's already the headquarters of multiple international and regional courts. We also heard yesterday that it could probably host one day a new center for the prevention of genocide. And we could also imagine ICC trials here if we opt out for a decentralized approach and have some trials outside The Hague. We also need these kind of hubs in Latin America and in Asia. That will allow us to have complementarity between the regional and the international level. These hubs need to work together and constitute a network against impunity to prevent and adjudicate atrocity crimes. But we've also heard, and this appeared multiple times during these 2 days, that these hubs need to be engaged in capacity building, as training is key for the success of investigations and prosecutions. However, and I'm going to say something very personal here, capacity building shall not be structured with a post-colonial mentality. We heard today that African states who were not part of the initial creation of international law need to take ownership of the system. So what we need is a 360 capacity building mindset, where people from the north learn from people from the south, people from the east can learn from people from the west, and vice versa. This is inclusive architecture. This is the future. Second, we heard throughout these 2 days that we need to build an efficient judicial system. I'm convinced that if our institutions do not deliver, they will disappear. Efficiency is not a luxury, it's our primary duty. We heard today that we need to improve cooperation. I quote the prosecutor Brammertz, criminals don't use diplomatic channels. So what do we need to do? We need to be faster than criminals. For this, we had a lot of examples. We need to cut red tape as much as we can. We need to use advanced copy, joint investigative teams. We need to bring on board law enforcement and intelligence agencies as soon as we can. And we also need to build informal contacts to enhance cooperation. In a word, we need to be pragmatic. Conferences like this one help creating trust between professionals. And direct interpersonal interactions produce judicial results. Without knowing each other, we must rely on multiple intermediaries, and that slows judicial process. Beyond people, we just heard that we need robust technology. The panel this afternoon demonstrated that if we are well prepared, if we anticipate, we can overcome even the toughest challenges. But we also need to be creative and be able to change our practices quickly. We can't stop functioning. To ensure efficient judicial system, we also heard yesterday that we need mechanisms to ensure that states cooperate with international courts. States need to be accountable before the institutions that they have chosen to create. And to be efficient, we also heard in the past 2 days that we need to work with civil society organizations. We need to engage with tech and social media platforms to fight hate speech. That has to be a priority against atrocity crimes. If not, it will come back. We need to engage with future generations. And I think the motto of our symposium will be from the courtroom to the classrooms. And we also need robust partnership with new types of civil society organizations. And I'm specifically thinking of organizations that are doing investigations. We have Bellingcat, we have the Coalition for Content Provenance and Authenticity, we have Eyewitnesses. All these civil society innovation bodies are now participating in investigations. We need to partner with them. We cannot ignore them, and we should not go against them. But more important than anything else for efficiency, we need hard-working professionals. We should not join international courts and tribunals for the privileges. We are privileged to work for organizations that have the potential to help thousands of individuals on the planet. Finally, and this is my last point, our debates showed that we need to truly hybridize our legal systems. Our main challenge is to build a form of new universalism that leaves spaces for various modes of implementation. And for this, everyone needs to be around the table. Everyone needs to have the floor. This is how we can harmonize legal standards without double standards. It cannot be a system that is imposed on the others, because the law needs to be the same for every situation on the planet. I've been very much inspired by the African judicial dialogue that we heard from throughout these 2 days. I think it's a tool to be familiar with the legal issues and to put everyone on the same footing. But the challenge of hybridization, and this is probably one of the most difficult things that we have to do when we are in international courts or tribunals, is that there are actually 2 types of hybridization, an easy one and a very difficult one. The easy one is the top-down one. It's the one that have been done in our statutes. You have diplomats who have negotiated in New York, in The Hague, or in other forum, and they have created these statutes that brings together the 2 traditions. But the most complicated one is the bottom-up hybridization. Because this one comes when we have a legal framework that is vague, incomplete, or where we have gaps. And why do we have these gaps? Because the diplomats have not been able to agree in the first place. And us judges, we are to do the job because it hasn't been done before. And this is probably the number one challenge for international criminal justice, because we are not only working in a system, we are also working on the system and at the same time. In fact, we are building a house in which we are already living. We heard 2 very interesting examples of these challenges yesterday. First, on victim participation. In the Rome Statute, there is only 1 article dedicated to victim participation. Why? Because there was so many disagreements in Rome that states couldn't agree on something that was meaningful and detailed. So what happens? It means that it's up to the judges to build the reparation system. And it's very complicated when you have judges who come from such different systems. So no surprise that when you do not do the top-down hybridization, it's much more complicated later. And I think the second very good example that we had was the cooperation between the defense teams and the states, especially when we had accused that were found unfit to stand for trial or who were acquitted. How do we ensure that there is a cooperation between the defense teams and states? Nobody had anticipated that. And it's very different if you talk to a civil law country and a common law country. And this is things that we have to do on the spot. And this is, in practice, harmonization. This is hybridization on the field. For hybridization to be successful, we shouldn't have the objective of imposing our domestic system. It's been that in The Hague for a long time and in other tribunals. We should take the time to listen. We should build consensus through compromises. And once we have a consensus, stick to it to ensure consistency. And I think the Chambers Manual at the ICC is an excellent tool for this bottom-up harmonization. This is how we can build a truly global justice system. Let me finish by saying that the past 2 days showed so much energy, knowledge, and openness that we can be really confident for the future. There was a lot of creativity and willingness to improve the system. I think we need to continue to work harder and faster for better results and stronger institutions. That's the direction I hope we will take. Harder, better, faster, stronger.
Thank you very much, dear colleague. Really, it was a magnificent summary of these 2 days. You mentioned many challenges we still have ahead of us, but your last words were really inspiring. Harder, better, faster, and I'm missing one, but stronger. This should be the conclusion, the final conclusion for this colloquium. Thank you very much. And now we have the privilege to hear from Judge Sekule. He will speak about the past of our institution, how everything started, but also the present and the future, I guess. So it is a real honor and privilege to have him here, and thank you for sharing this opportunity. Judge Sekule, you have the floor.
Yes, President Gatti, Judge Golio, honorable guests, esteemed colleagues, it's an honor to participate in this closing panel and reflect upon where we, as members of the international criminal law community, have been and how far we have come. I was one of the original 6 judges elected by the General Assembly to the ICTR in 1995. My first colleagues were Judge Lait Kama from Senegal, Judge Ostrowski from Russia, Judge Pillay from South Africa, Judge Aspgren from Sweden, and Judge Khan from Bangladesh. We had a shared appeal chamber with ICTR that was based in The Hague. The original judges on appeal were Judge Abi Sabu, Judge Kasese, Judge Deshanis, Judge Lee, and Judge Stephen. We made a solemn declaration on 27 June 1995 in The Hague. At the first plenary, we elected Judge Lait Kama, our first president, and Judge Ostrowski as vice president. I became the presiding judge of Trial Chamber 2, a position I held till I joined the appeal chamber in 2013. At 51, I was the youngest of the trial judges in the beginning. Looking back now that I'm in the upper echelons in age among international criminal law judges, I must pay tribute to my former eminent colleagues. It was my great honor, privilege to be associated with them. The beginning days were uncertain. We had no clear roadmap. Initial hearing involved simply pushing chairs around the table in a nondescript room. We came from civil and common law jurisdiction and had to work across legal tradition and languages. At the beginning, the elements of crimes, even the most basic aspects of procedure, required extensive discussion before we reached common ground. Notwithstanding this new and uncharted judicial environment, the spirit of fulfilling the mandate handed to us by the UN Security Council was unquestionably present. As the ICTR work expanded, we added a third chamber. We added ad litem judges. We added staff. We grew. Always doing justice was at the forefront of our mind. I'm so proud of the staff that we had and where they weren't. Two of my former legal officers have become mechanism judges. Undeniably, a key legacy of the Ad hoc Tribunal is the development of the precise contours of international crimes. Significant ICTR, time and again, provided definitive interpretation of genocide convention. Rape and sexual offense were found to constitute acts of genocide. What type of speech amounts to establish direct and public incitement to commit genocide has been extensively elaborated. The Ad hoc Tribunal and its successor, the mechanism, have likewise defined crimes against humanity, war crimes, taking bold steps in articulating customary international law. Common Article 3 to the Geneva Convention and Additional Protocol 2 were applied for the first time in criminal context to internal armed conflict. The ICTY Appeal Chamber specified elements of torture in an armed conflict. The Appeal Chamber of the ICTR and the mechanism considered how speech, hate speech in particular, may constitute underlying acts of persecution as a crimes against humanity. The ICTR Appeal Chamber has extensively considered when and under what circumstances a civilian can be considered a combat in the context of war crimes. More recently, the Mechanism Appeal Chamber articulated the precise legal test underpinning the principle of distinction as applied in the law of armed conflict. These are just a small number of examples. Our jurisprudence, developed over nearly 30 years, is one of the richest legacies and serves to guide subsequent international courts' domestic system as accountability in the aftermath of war. The Ad hoc Tribunal have also effectively balanced evidentiary principles, incorporating common law and civil practices to provide effective and fair trials following mass atrocities. For example, the admissibility of hearsay has played a crucial role in developing a more complete record of grave crimes. Nevertheless, the Judicial has established principles to ensure that such evidence is treated with sufficient caution, that its weight and probative value are carefully considered in light of the nature of such evidence and the totality of the record. Today, thanks in part to the development in law and practice of the Ad hoc Tribunal, international criminal law is fixed in the public consciousness as an essential component in reconciliation following war. No country, no one thinks that there is no need for accountability for international crime. I believe there is now a universal acceptance of this principle. Our jurisprudence, richly developed over 3 decades, shows that we can handle any cases that comes. However, progress to implementing accountability for international crime is slow, but there is progress. As the ICTY and ICTR reach their stride, the international community saw that what was once the vision of academics could be a reality. It has since repeatedly come together to provide accountability for international crimes in Sierra Leone, Cambodia, Lebanon, Kosovo. Progress is also evident in the proliferation of domestic special prosecution units and courts to try grave crimes in violation of international law. Rwanda and the countries of the Balkans have taken the reins in adjudicating cases over which the Judicial Tribunal once led the way. Uganda has set up their own specialized court and prosecution units to pursue international crimes. European countries are following suit, trying war crimes suspect from war-stricken countries. The practical challenge faced by domestic jurisdiction in prosecuting international crimes has been faced with bold resolve. The Judicial tribunals further paved the way for the Permanent International Criminal Court, which stands as a warning that there is collective resolve in ensuring accountability following mass atrocities. I want to take this opportunity to say that my personal view is that Africa should remain engaged in the international courts and the ICC. We should develop and strengthen our regional courts and continental courts in Africa. Africa can be a peacemaker and deliver justice. We have come a long way from holding hearings in makeshift rooms. The mechanism now has some of the most advanced courtrooms in the world. The system that has evolved from this humble beginning has sent dedicated and committed judges, staff, prosecutors, and defense attorneys to other international, regional, and domestic jurisdictions to pursue justice. As I close, again, want to pay tribute to judges whom I started, and all the judges I have worked with over the last nearly 30 years. I want to note that our former prosecutor, Hassan Bakar Jallo, is now the Chief Justice of the Gambia. One of our first Chief of Prosecution, Honorable Judge Othman Chande, served as the Chief Justice of Tanzania, and he still plays significant roles in my country and with the United Nations. I also want to thank our legal our support staff, who tirelessly help us fulfill our mandate. You always have your hands on the moral arc of the universe and help push it towards justice. It has been a long, challenging, rewarding journey. The struggle for international justice continues. Thank you for your kind attention.
Thank you, Judge Sekule, for reminding us everything that was done in the past, but also for telling us everything that has to be done in the future. And, well, this is why we are all here, trying to work for a better international law, a better world. And now, with sadness, I have to say the last words of this colloquium, because over the last 2 days, we have had the privilege of listening to rich discussions on the most recent trends and developments in the area of atrocity crimes proceedings. First, we were warmly welcomed by our formidable host state through wonderful remarks and words of support from Honorable Ambassador Dr. Pindi Hazarachana, Minister of Constitutional and Legal Affairs. I had the opportunity to sit with my dear colleagues, Justice Kayobera and Lady Justice Aboud, all presidents of the three Arusha-based courts to present on our roles and contributions in advancing international justice. Our keynote speaker, Mrs. Alice Ndiritu, delivered a powerful message to the Second Judicial Colloquium through her historical statement, From the Courtroom to the Classroom, and thank you for helping to shape the new face of atrocity crime proceedings. I also wish to praise our distinguished panelists and moderators. Thanks to all of you for sharing your expertise and your knowledge. Certainly, I will leave this colloquium having learned a lot, but maybe even more importantly, having forged important acquaintances and professional networks. The mechanism will continue to work with and strengthen ties with national and international judges, as well as other actors working in the field of accountability, particularly in East Africa. We have just heard a wonderful closing segment in which Judge Guillou has ably provided an overview of the main takeaways of all the panels, and Judge Sekule's remarks was a tour de force. I cannot imagine a better ending to this colloquium. A massive shout out to our dedicated team, whose hard work and commitment made our participation in the second Judicial Colloquium an outstanding success. Let me say that your passion for excellence is truly the driving force in the office of the President. I also want to recognize that we could not have pulled this off on our own. We relied tremendously on the registry. Thank you, Registrar, for your leadership and for your support, and a special thank you to the sections of Visa and Protocol, General Services, Procurement, Finance, ITSS, and Security. I will be very pleased to report back to Donald Ferencz when I thank him again for the contribution that he and the late Benjamin Ferencz have made and the impact that Ben's legacy continues to have around the world. Finally, thank you to all the participants and in particularly the judges, including my colleagues, for making the journey and taking active part in our discussions. And now, sadly, as I said at the beginning, I must declare the second Judicial Colloquium formally closed. Thank you all for being here.